Hello, everyone. Welcome to this episode of the Legal Paige podcast. Today's episode is another solo episode from yours truly. And today we are talking about the 10 essential contracts that you need in your small and growing business. Now, in this episode, I'm going to go through every single contract, the 10 most important ones that you probably should have. And if you don't have, you're going to want to figure out how you can get them. So without further ado, I'm just going to get straight to the point. Let's get into this episode. You're listening to the Legal Paige podcast, where we chat about life and business with a legal twist. I'm Paige, attorney and photographer helping online businesses and creatives tackle their business dreams without breaking out in hives. No more legal mumbo jumbo. This podcast features simple, bite-sized advice that'll have you legally legit in no time. Are you ready? Let's get started. As a reminder, before we get into this episode, I am legally obligated to give my disclaimer. So I am an attorney, but I am not your attorney. All legal information I talk about on this episode is intended for the masses and a large variety of different businesses. I am only your attorney when you hire me and we sign an engagement letter for me to work specifically on your legal issues. Please feel free to seek out another attorney in your hometown if you need specific legal advice or contact me for more information. Alrighty, here's the episode, friends. Hey there, Legal Pagers. So obviously we are talking today about all of the essential contracts that you need for your small and growing business. And as your business grows, you are definitely going to need to implement more and more contracts into your business. With that being said, I just want to talk a little bit about why this is such a hot topic right now. So I work with a lot of different entrepreneurs across the online industry. So primarily people from the wedding industry, whether that is photographers or videographers or say wedding planners, and the full gamut. I've worked with florists and all kinds of people. But I also work with people that just run online businesses like registered dietitians, health coaches, life coaches, website designers, website developers as well. So the back end of that, people who are social media marketers. You guys, I work with tons and tons of people who run their businesses online. So with that being said, all of these different people who are running different types of businesses are going to have a different client contract. And I think there's this misnomer in the industry that the client contract is it. Like that's all you need to have to protect your business and be squared away. And that's like a huge mistake lots of entrepreneurs are making, is they think that that is what's going to save them in the end. When in fact, there's other things you need to set up in your business contract-wise to ensure that you're covered and protected. Now, I'm going to go through the 10 essential contracts that you need as your business grows and things that you probably need right now as you are in the, current status quo state that you probably don't have. And if that's the case, I just want you to go look into getting one of these contracts to ensure that you're covering yourself even more. So the first contract we're going to talk about is the LLC operating agreement. The reason that I am talking about that first is because lots of people either become a sole proprietor or a limited liability company. And I'm not going to go into that in this episode. I have other podcasts talking about the difference between a sole proprietorship and an LLC, and you can go find those in the Legal Paige podcast. So I'm just going to go into why an LLC operating agreement is so important. And it's a contract. So when you create your limited liability company, which of course I preach to everyone is the business entity that everyone should be if you are acting as a single member who's owning a business, that is definitely the one you want to look into for liability purposes. But when you register your LLC with your state government, you can file, it's optional to file an operating agreement. Some states do require an operating agreement, but most states it's just optional. And lots of people just do not file them. One, because they're tedious. Two, they're very hard to like understand what's in them. And three, people don't really know like why you actually need it. Like, is it necessary when you're just a sole member? And the answer is yes, because it is really, really important. You never know what's going to happen later on in the future, whether something's going to happen with your business, you're going to have to wind up the business assets and dissolve the entity. Say you add another member in, say someone buys your company from you. If you have a standard operating agreement that you had from the get-go of you operating your business, and again, even if you didn't file this at the beginning of when you registered, you can still implement one right now today. So an operating agreement is just critically important to your LLC because it defines literally everything that involves your business practices. So who owns the LLC, right? It's probably member managed because you're the member and you're managing it, and you don't have some like hierarchy of like there's people down below, some managers or anything like that. So you're probably a single member managed LLC. So you would want to put your name on the operating agreement that you own it. And so there's no discrepancy in the future that someone else could potentially claim ownership to it. Also, an LLC explains how it's going to be managed. And I just explained that. So member managed is usually the default rule in most states. And so you're probably going to be a member managed LLC. You're the member. You're the one making all of the decisions. You don't have to report to anyone higher up. Then it's going to explain the owner's responsibilities and obligations. So what does the owner have to do day to day? Do they have to file reports, profit loss statements, all of those things? What happens if there is a liability or a risk assessment with the business? What are the managers or members' role in that respect? Then whether it should be taxed as, say, a partnership, an S corporation, or a sole proprietorship and pass-through entity. So some people know that this is how they're just going to be taxed as, say, a sole proprietorship, pass-through taxation entity. You're the only owner of the LLC, and then it's going to pass through to your personal tax return. You'll want to indicate that. But say you are a partnership and you're creating an LLC, you definitely want to ensure that you have an operating agreement if you are owning the business with another person, because that's vitally important to explain each partner's roles and responsibilities in the LLC, risks and liabilities, yada, yada, all of that is in the operating agreement. But then it would explain whether it's taxed as a partnership or an S corporation. If you've elected to be an S corporation through the IRS, then you'll want to put that in your operating agreement as well. And then the operating agreement it further explains like everything regarding winding up, dissolving the entity if you were to sell it, how you explain all of the assets that are involved or that you own in the LLC. So the LLC operating agreement's really, really important, and lots of people just have how they operate their business in their heads, but they don't actually document that on a piece of paper. And so right now, if you don't have an operating agreement, I want you to check into getting a template operating agreement. I have one in my shop. And of course, you will listen to some good news that I have about this week and what we are launching. So you want to take a peek at that on how you can get access to an operating agreement. Now, the next contract that's really important is a master services agreement, or an MSA. And this is, you guys, just your main client contract. You don't have to call it an MSA or a master services agreement, but this is the big kahuna, the client contract, the one that everyone knows they need to have, and it's essential to have as a business owner. It's going to have all the terms and conditions of a client trying to hire you to do something for them that's specific to the service industry. So if you have tangible products, or you're giving them an online course or something like that, that would be a different type of contract. But this is a master services agreement. So I'm talking to all of you out there who are service providers. You're giving your clients some type of service. And that being said, you need to lay out what they're going to pay you, what your refund policy is, your cancellation and termination policy. Rescheduling situations, can they reschedule? This is really important for like coaches out there, life coaches, health coaches who have coaching calls. I've been working on a lot of those client contracts lately, and I've noticed that a lot of things are missing regarding rescheduling and the program period and if calls roll over. And there's so much confusion with that when you have coaching calls and people expect to get their, say, 8 coaching calls in those, 12 weeks or something along those lines. So you want to lay that out in your master services agreement. And of course, all of the essential clauses that we have gone over in previous episodes before as well, like limitations of liability, indemnification, severability, transfer clause, venue and jurisdiction clause. All of that boilerplate language needs to be in there as well to save your patootie. Now, the third one we are going to discuss is the employment section of the essential contracts you need to have in your business. So I'm going to go through 3 of them. Actually 4. The employment offer letter, the employment agreement, the employee handbook, and then the independent contractor agreement. So we're going to go over employees first, because what often happens with small and growing businesses is you're likely going to, at some point, switch from either being by yourself and hire like a contractor, and then sometimes at that point you even switch from having contractors to bringing on employees, part-time or full-time, because you have people in the office. You need to control what they do a little bit more. You want to control their hours, what they're working on, their projects, all of those things. So that's when you bring an employee on board. And when you have an employee, the first thing you want to start with is an offer letter. And lots of people forget this step. It's very, very important because it protects your business from legal liability and misunderstandings with an employee if something were to happen like before the employee starts or after the employee starts and you have some type of discussion or, there's miscommunication regarding what the offer letter said or what was promised to them, quote unquote. And that's what usually happens is it's a lot of like, he said, she said, this was what was promised to me. And now this is what is in my actual employment agreement. I didn't agree to this. So you want an offer letter. You want something that states and is issued to your prospective employee that they need to sign and they need to agree to what you are offering them. And that really just evidences the scope of the entire employment relationship between the parties. So the job offer letter is going to include responsibilities, like why you are hiring them and what their job responsibilities are, salary, or if you're paying them hourly, any benefits, if you're offering health benefits, if you're offering paid time off benefits, anything like that, a start date, and then whether they are like an at-will employee or say you can only fire them for good cause, and they might have a probationary period or something along those lines. All of those things are encompassed within the job offer letter. So that's really important. That's document number 1. And it is a contract because the person is signing it at the bottom and you are offering it to them. So offer acceptance, consideration, and of course, that's a contract there. So with that being said, it kind of goes hand in hand with the podcast episode we had last week with some big overall general legal concepts regarding contracts. You want to ensure that the person is agreeing to working for you so that they don't like leave and you're, kind of out of luck, and vice versa. You don't want to put them in a position where they have agreed to work for you and then you just like don't hire them or you're not holding up your end of the deal as well. So that is the employment offer letter. Of course, there are tons of situations like financial situations, and there's lots of things that could occur between having them sign the offer letter and having them start as an employee. And there's all kinds of arguments that can be made that, of course, things come up and like sometimes it just doesn't work out. But it's really, really good to have that offer letter for those misunderstandings that could happen potentially happen in the future. So the next one is the employment agreement. And sometimes I call it employment agreement, employee agreement, same. So the employee agreement is obviously for those that you hire on only as employees. And it specifies, of course, the rights, the obligations of your full-time salaried or part-time employees. It really, really clarifies what is expected of the employee and also what's expected of you as the employer, to, again, avoid just all of those conflicts. And you want to address these important aspects of the employment arrangement within this agreement. So it's going to have things such as wages and other compensation, benefits, duties and responsibilities, working hours, the position that they are being hired for, confidentiality. You can have non-compete clauses in employment agreements, which is awesome. Of course, non-solicitation, and then anything regarding termination or probationary periods, that all needs to be in the employment agreement. So again, you send them the offer letter, and then they would start, and on the start date, they would sign an agreement. And then after they sign the agreement, you're probably going to want some type of handbook. And a handbook is really good because you also kind of want it to be a contract. These are the essential contracts you need to have in your business. And a handbook is something that they can, of course, take home and read, but you want a contract that they sign that says they read the handbook. That's very important. But the handbook obviously includes all of the guidelines and what's expected of them working for you. If there's any type of dress code, if there's any type of stipulations regarding when they are in the office and how much PTO, everything is laid out. Sometimes it's a reiteration of what's in the employee agreement, but a lot of times it's extrapolating upon that. So all of your business procedures, what is expected of them, is in the employee handbook. And then you want to have a contract that they sign off that they have read the employee handbook. So those are the three biggies for employees. The other one I just wanted to discuss is an independent contractor agreement. That's what a lot of you probably tuning in are going to want, because lots of us aren't quite ready to hire employees yet. We're not that mature of a business. That's a lot of liability to bring onto your business as well. You can probably just get away with having like a virtual assistant and contractors that are all over the country helping you, because we live in a virtual world. And it's super awesome because we can all connect virtually. So if you have an independent contractor, please, please, please do not hire them without an agreement. And this is a mistake that unfortunately lots of entrepreneurs make. We all have good intentions when we go into relationships like this. And oftentimes we're hiring friends or friends of friends, people we've been referred to, and without an agreement, though, you are setting yourself up for failure, because there's always going to be some type of miscommunication when you're working virtually with someone. And I see that, honestly, you guys, probably 9 times out of 10. So with that being said, please take my suggestion and get an independent contractor agreement. So these are consultants or short-term employees. They're likely working virtually for you. They should be. If they're in the office, that's very, very, very close call for whether they're an employee or not. So a lot of these people need to be working virtually or remotely. And then you just want to outline, again, your obligations, their obligations of working for you, the rate that you're going to pay them, or you might pay them like a stipend or monthly basis. Sometimes we hire like a copywriter per se, and they're $500 a month for these different things that they will copyright in your business. Non-solicitations, you can have non-solicitations in your independent contractor agreement saying that they can't steal your clients, or any clients, customers, prospective clients. They can't steal them from you and poach them. A non-disparagement clause is really important to have in an independent contractor agreements. It just says you're not going to vilify one another, talk bad about one another online. That's really good for people who have tumultuous relationships that end up breaking up, and you never can foresee a sticky situation happening, and then you don't want someone to go bash you online and vice versa. So termination at any time also needs to be included in independent contractor agreements. You cannot say that they cannot cancel the contract. If they are truly an independent contractor, you should be able to terminate them at any time, and they should be able to terminate at any time. But that clause, of course, wants to also state that if any services are rendered, like if the independent contractor is let go, that any services that they have performed up until that date will be paid by you as the company. That kind of thing needs to be in your contract as well. And then I also just want to point out there's much, much more that, of course, is in an independent contractor agreement. But these are just some biggies that need to be in there. The one thing I see often missed in independent contractor agreements is invoicing. So they are not an employee. So you can't track their hours. They can't just tell you how much, to pay you every month. You can't just direct deposit it into their bank account. They need to send you an invoice as if they have a business and they are contracting to work with you. That is the relationship you are creating with them. They need to invoice you. They need to send you either just a PDF invoice and then you pay them somehow through direct deposit. But I want actual documentation that they are invoicing you every 2 weeks or every month or however you have decided to pay them. Invoicing is very important. It structures them as an independent contractor. Now, the next one I want to talk about is in relation to employees, and this is a non-compete agreement. So you can put a non-compete clause in an employee agreement, but I always suggest having it as a different document. And the reason why is because employees want to know exactly what they're signing, and a non-compete agreement is so clear when they sign an actual different document versus hiding a non-compete clause in a middle of an employee agreement. There's lots of defenses to contracts there that a lawyer could make. So with that being said, you just want to have a completely separate agreement that they sign. And this is really important for people who say, the best example I can give is a florist. So florists have very specific way that they design their floral. And I had a situation with a client. This is why I think this is a good example, is because they hired on someone to work for them. They had a brick and mortar. They had worked for this person had worked for them for over 2 years. The owner, he taught her everything that could potentially that he knew in his business. He taught her everything. He taught her how to style the floral. He taught her how to run a business. He taught her how to have effective client communication. And especially because it was kind of a smaller town, it was really important that they signed a non-compete agreement. And in the non-compete agreement, it said that this particular employee, during, of course, the time of employment and for a 2-year period after, they could not compete. So they could never start their own business. And when you have employees, that's kind of one of the big benefits of hiring an employee is you can have them sign a non-compete. You cannot have an independent contractor sign a non-compete because they are independent. Remember that word. And that's a misnomer in the industry as well. But a non-compete agreement is something that they signed, and it saved this company in the long run, because what happened is she ended up leaving, and it wasn't right away, but about a year later, she started doing some floral work and was trying to start her own business. And it was such a small community that there was a connection to the previous company that she worked for. And they were actually able to have her stop trying to create her own business because of the non-compete. So it saved that business, and it saved that business lots of money, lots of client confusion, lots of issues with potentially this other person soliciting their clients and losing money in the long run. So a non-compete agreement is very, very important. In addition, you guys, a non-compete agreement typically restricts an employee's ability to work for a competing business within a specified geographic area. And then, of course, like I said, for a specified length of time. Usually it's 1 to 2 years. So that's everything about a non-compete agreement. So far, you guys, we are at 7 agreements. We've talked about the LLC operating agreement, the master services agreement or your client contract, an employment offer letter, an employment agreement, an employee handbook and a contract that they sign, an independent contractor agreement, and a non-compete agreement. The 8th one that we're discussing is the confidentiality agreement. A confidentiality agreement is something you're going to have an independent contractor sign and an employee sign. Both should sign it. Again, all of the things I said about a non-compete agreement also apply to this. I think that a separate document is really important. An NDA is what they're usually called, non-disclosure agreement, and that's important because what is within a confidentiality agreement is that they are going to keep your proprietary information safe. So any type of confidential information that you have in your business, whether that's email templates, whether that's how you edit, whether that's how you run your business, your pricing, your customer list, all of those things are confidential, and they need to keep that confidential for a specified period of time. And of course, during their working relationship with you, whether that's an independent contractor or an employee. So that's a confidentiality agreement, and they should definitely sign that. I get questions all the time if NDAs should be signed, and the answer is always yes. Just like sign an NDA or have someone sign an NDA for you, because the chances of them having like some access to proprietary information in your business is very high. The last two are in regards to your website. So lots of us run virtual businesses, and the two final contracts that you need to have in your business is a website terms of use agreement and a website privacy policy. And I'm not going to go into too much depth here regarding these two contracts because I do talk about them in episode 6. So you can go and refer back to that. But just know that if you have any type of viewers or users of your website, that you need a terms of use agreement. So this is a contract, of course, between the website owner, which is you, and the users of the site. And of course, if you have like an online store or anything along those lines, then the terms and conditions of use of the website would also cover purchasers of goods or services from the site. So the agreement includes limitations on how the site can be used. Obviously, you want to have copyright protection warnings, any type of disclaimers, like if you're a life coach, but say you're not a doctor or a clinical, trained therapist, or you're not an attorney or any of those things, you want to have those type of disclaimers on there. Liability limitations, disclosures on the site's privacy policy in dealing with customer information. That's within the privacy policy, but I always link to it in the terms and conditions of use because a user is going to look at one or the other. And then of course you want to link to the other one so they have instant access to the privacy policy as well. A website terms and conditions of use is also going to have like the jurisdiction where any disputes may be brought, because ideally you want it to be the hometown and the home county of the site owner. There's been lots of lawsuits I've been a part of or worked on that had to do with venue and jurisdiction with online service providers, and they want to sue like in a completely different state than where the owner of the business is, because the person who accessed that site was from this other state. So to avoid any of that, just make sure you have all of this within your website terms and conditions of use. And that is an agreement that you would put on your website. That's one page on your website, and then you want to have a privacy policy page on your website. I think these should always be separated in two different things, and then you just link to one another, because how someone uses your website is different than you taking their private personal information. And that's what a privacy policy is. It is required in the United States if you are taking any type of information from someone. So if you have an email like newsletter and you're having people sign up for that email newsletter, you need a privacy policy, and it's going to tell that person when they send you any type of personal information that they have, how you will use that data and information that is collected from them. A privacy policy is also required if you are collecting any data from users of the website, which you probably are on the back end with like Google Analytics. So you need a privacy policy on your website, people. So that's enough of that. Just get a privacy policy, get a terms and conditions of use on your website. Those are the last two contracts. So again, we've gone through 10 essential contracts for your small and growing business that you're going to need at some point, if not now. You guys, thank you so much for joining me on today's episode. Cheers, Legal Pager. I love you. Thanks for tuning in. Thanks so much for listening to this episode of the Legal Paige podcast. See, I told you being legally legit isn't so scary. Be sure to visit thelegalpage.com for all show notes. And it would be super awesome if you could head over to iTunes and leave a review. Last but not least, don't forget to join my free Facebook group for unlimited legal and biz Q&A. Chat soon, Legal Pagers.